come to the technical session 12, Global Patent Litigation and Enforcement Strategies. Do we have Mr. Nirav Desai, Gururaj Bagalkotker, Abhijeet Patil, Pratik Chaudhari, and Mr. Hemant Singh. So greetings, strategists in patent litigation. I, Ashwini, welcome you to an insightful session on the global patent litigation and enforcement strategies. Think globally, draft strategically. Delve into effective patent filing strategies crafted for a global stage. Allow me to introduce Nirav Desai, partner, Sterne Kessler Goldstein and Fox. Nirav is a director at Sterne Kessler, specializes in patent litigation and global IP strategy, presenting a wealth of experience in the district court cases before PTAB and USITC. So I'd like to introduce him. He excels in simplifying intricate legal matters both inside and outside the courtroom, specializes in patent litigation and global IP strategy. He served as a lead counsel in district court cases nationwide and has extensive experience before PTAB. With over 25 PTAB proceedings, he strategically combines district court and PTAB expertise for a comprehensive legal approach.
But I'm hoping he'll join us as we progress here. So let me just say thank you for joining us for this last panel session of the day. There's a lot of dedication in this room. I know it's something like 5:30, 5:40, and I'm sure everybody in this room probably has something else they could imagine themselves doing on a Sunday evening. So I really appreciate you sticking here to the bitter end with us. If you were in this room for the immediately preceding session about global filing strategies, this panel is somewhat the other side of the same coin. This panel is about global patent litigation and enforcement strategies. And so, very much two related concepts. And I think, we've talked about, throughout the day, we've talked about, in the context of the theme of our conference, innovate, protect, and scale. I think Hemant Singh said it best on one of our earlier, in the inaugural panel, that why innovate if you can't protect, right? Why seek patents if you can't enforce them? And while a lot of our discussion has been about maybe some of the flaws in the Indian system or the US system or any systems around the world, and certainly there's a lot of ideas in this room about how to improve those systems. In parallel, we have to really work within the system that we're given. We have problems to solve today to help our businesses, our clients succeed. And a big part of that is using the systems that we have available to us to facilitate success among our clients. So you can a big part of that I've seen in my practice is this sort of rise of multinational litigation, parallel litigation. You can call it IP arbitrage, you can call it forum shopping, but it's the idea that if I'm having trouble accomplishing my IP goals in one forum, I might need to look at another forum to address that issue. So if I can't get a preliminary injunction in the US, maybe I need to look at Brazil. If I can't get a software patent in India, maybe I need to look at Singapore. If my patent is unlikely to stand up to a validity challenge in one forum, maybe I should be bringing my enforcement proceeding in another forum. And so that's really what we wanted to talk about today, is the idea that we as IP professionals, faced with sort of the weaknesses that we might have in our respective systems, and of course always working to improve those systems, we still have to find ways to use the systems that are at our disposal to get good results for our clients. And so with that sort of context, I'm gonna pull in my fellow panelists here. And I'm going to, rather than me go through their bios, I'm going to ask them to say a little bit about their respective practices, but with a particular emphasis on on the impact of global litigation on their, either on their role or on their day-to-day responsibilities. And so maybe I'll start all the way at the end there with Pratik. Maybe you could say a few words here.
So, thank you, Nirav. The title for today's discussion is quite intriguing for the reason that since considering the case that in the global scenario today, the jurisdictional barriers are now diminishing. Because of the rise in economy, the Indian companies are venturing out into other countries. They are getting patent protected in those other countries. The big companies from Europe and US, they are investing in India. They are seeking patent protection in India, and they are also going forward with multi-jurisdictional approach to get maximum patent protection as much as they can. Now in this scenario, what happens is that suppose generally the aspects or the problems which we face, which we have seen during our practical litigation which we are handling through the firm. Suppose consider a case that a company has got a patent in one jurisdiction. It is already enforcing it against one party. That very defendant is also infringing the very patent in India. But the plaintiff in that other country does not hold any patent in India. What can such a plaintiff do? It's a practical aspect. We are already handling one of such cases wherein one of the plaintiff has a software patent in US. That plaintiff is litigating that matter like anything in US. But since they do not have a software patent in India, because the software under section 3K of the Indian Patent Act, the computer related inventions are not patentable, though the horizons of 3K are being expanded. Now many such computer related inventions are being granted patent in India, but they unfortunately don't have a patent in India. So they have filed a copyright infringement case against our client in India. This is also one of the strategy, pursuing two different types of litigation against the same party, because you hold two different types of intellectual property protection. Copyright protection for a software, it being a global protection, you can pursue it in any country. You don't need a registration for copyright protection, copyright registration. So they are litigating in two different jurisdictions for the same thing under two different kind of IP. Now in such a scenario, how do you defend your client in two different forums under two different kinds of intellectual property protection? That is where the strategizing your litigation comes into picture. Because the law may be in your favor, it may not be in your favor. The facts may be in your favor, they may not be in your favor. Then comes the question of strategizing your litigation aspect. Luckily, in the US jurisdiction, because there is a jury system over there, we could establish that, the other side could establish that indeed our client was liable for patent infringement in US. And the jury gave a decision in favor of the plaintiff. But on the motion to dismiss on the point of law, we could establish that it was not an enforceable patent in US. And the judge gave an order in our favor, declaring that it is not an infringement because it is not a protectable patent. As far as India is concerned, they tried to establish that it's a copyright infringement. It's a substantial and material reproduction of the object code and source code. Right? But here we could do in such a fashion, or we could strategize in such a fashion that we could establish that although the US judgment is not enforceable here, it does not affect the litigation going on over here. But comparing two softwares in India, it is a difficult task for a judicial system. they need experts to do that. It is not a cakewalk. It is not a trademark case wherein 2 marks can be compared directly and it can be decided whether there is an infringement or not. It's a software. You need technical expertise for that. And hence, an injunction is still quite far away as far as the Indian system is concerned. So, because of such aspects, I personally feel that the law may favor you, may not favor you. The facts may favor you, may not favor you. It is all about how you employ those legal provisions and what chronology you adopt in order to protect your client in such kind of multi-jurisdictional infringement actions. This is what I feel about it. Thank you.
Yeah, thank you, Pratik. So Pratik is a litigator here in India. I'm a litigator in the US, and we face that same challenge that you have to deal with the facts that you're given. You have to deal with the portfolio that your client has. It may be optimized for the US, but not for India. It may be optimized for Europe, but not for the US. And we have to take it as it comes. If there's parallel litigation going on, you have to figure out how to strategize and how to coordinate among those jurisdictions. And that's just part of the challenge it's part of the reality of the IP ecosystem that we live in. So next, I'll come to you, Hemant Singh, you're, as the founder and managing partner of INTTL Advocare. Talk to us a little bit about how global patent litigation has impacted how you run your firm and the kinds of work that your firm does.
Thank you, Nirav. I have been in litigation since 1984, and I've had good fortune of having handled close to 3,000 IP litigation cases. I would say that the topic which we are discussing today has never been more relevant than what it has become now. It's the right time to discuss it because the dimensions have really changed over the period of time, and I'll tell you why. We are talking today in terms of innovations. I will focus more on that because that's where most of these global strategies are coming in. Trademarks are more territorial, so you have to go for territorial protection, except in cases of passing off, which is based on common law rights, transborder reputation, which is again very localized issue in terms of the evidence of reputation, etc. Copyright, of course, is across the globe. You don't need any registrations. You can claim a copyright the moment the work comes into creation. It's the patent which is global in nature because your business is global in nature, right? And your business is innovation driven, and you need to protect that innovation in every market where you're carrying on business. And patent is territorial. So look at the interesting dimension. You have a global innovation, you have a global business, but you have a territorial right to protect and enforce. And that's where this global strategy for your patent protection and enforcement becomes extremely relevant. And therefore, you actually need to strategize globally when you are seeking to protect your innovation in any jurisdiction. And that's why you can see the PCT has come in to facilitate that. In order to facilitate this kind of global protection. Now, my experience recently had been because there has been a lot of patent infringement cases now in India. And being based in Delhi, fortunately, a lot of that has come into our basket and has given us far more opportunity than to my friend Pratik in Ahmedabad. Pharma and telecommunication are dominating. In pharma, we have challenges which are very peculiar to India because of Section 3D, which is not there anywhere else. And most of the patents in pharma, it's not the molecule which translates into a drug, it's a molecule into a salt, into formulation which translates into a drug, and therefore Section 3D becomes a major challenge to overcome here. On top of that, we have had this judgment from our Supreme Court, which said that what is enhanced therapeutic efficacy and which is not enhanced therapeutic efficacy. Now, when we enforce a patent in case of pharma in India, you can't be just looking at your own specification, your own prosecution history in India. You have to look at the specification, the claims, the prosecution history, the disclaimers and everything in major jurisdictions. So when a patent is protected in India and when it comes to enforcement, you can't enforce it unless you have examined the prosecution in all the jurisdictions. That's where a global strategy comes into picture. One. Secondly, India, as we all know, is the as they call it, the pharmacy of the world. Like you have all the generics here. And these generics, when they apply for approval in US, you know, US and Europe, they have this patent linkage. Then they have a very advanced jurisprudence which we don't have in India. There you have to petition to the court and seek approval where the notice is given to a patentee. And when a notice is given to a patentee before an approval is granted, he has a right to file a suit for infringement. That suit for infringement is filed in US, having ramification in India because those generics are from India. Right? And then when you are prosecuting those proceedings in US, you also have to look at India because you have to ensure they don't launch in India. So therefore, any strategy which is put into place to initiate infringement proceedings in US, qua the generics in India, have to look at India, China, and other jurisdictions, right? That's therefore a domain where the global strategy has to come into the play. The other area is the telecommunication, which involves these SEPs, where you have these FRANDs issues that come, and now we have had judgment from Delhi High Court which says that there can be an injunction in respect of SEP. You know, where even there's a FRAND issue involved, there can be an injunction. You have these pro tem orders which have been passed, which is that interim royalties which can be asked to be deposited by a court against an unwilling licensee. With that, and these disputes are no more confined only to one country because they are, these technologies are global. They are being used by the implementers globally. And when they are being used by the implementers globally, they are being sued globally. So you have a patentee suing an implementer in Germany, you have the patentee suing that implementer in India, you have the implementers suing the patentee in China and vice versa. And therefore the issue arises in terms of which court is going to determine the issue. And the court which is going to determine the issue is going to determine the issue of royalty globally or territorially. And this continues to be a big discussion and a debate as to when you have different courts which have seized of such matters are proceeding to decide the royalty rate in different jurisdictions. How do you reconcile it? And how does an implementer then fight the same battle in different jurisdictions? So that's another example of global strategies coming into play for a patent enforcement or defending a use of a patented invention. And therefore, to answer your question, at least in terms of patent enforcement, a patentee who is a global player, having global patent, when initiate any infringement proceedings in one jurisdiction, has to have a global strategy, which means you have to examine what are the laws in different countries, what are the loopholes, in those countries. More important, you have to be consistent in terms of the submissions that you're making before a patent office. What submission you're making before a USPTO, what submission you're making before an EPO regarding your innovation and a claim, how are you distinguishing a prior art in one jurisdiction, how are you distinguishing it in the other jurisdiction. There has to be consistency about it. And in case there is inconsistency, which is bound to be there because some jurisdictions are more lenient in terms of granting you broader claims, some are more strict in terms of granting you narrower claims. Somewhere you don't have a very stringent inventive step, and therefore your submissions in terms of distinguishing prior art may not be consistent or the same. All that needs to be examined before you initiate infringement proceedings. And therefore, I believe, if I may answer your question, that patentee having global patent and global business has to have a global strategy.
Yeah, that's great insight. And so 2 points I'll follow up on there, and then we'll move to Abhijeet. A lot of times when we're talking about global enforcement, global litigation, global anything, we talk about countries in a very homogeneous way. This is what happens in the U.S. This is what happens in India. But to your example of courts in one country looking at what's happening in what happened in prosecution in another country or in a proceeding in another country, I can speak for in the U.S. Judges are not all built the same in that respect. Some judges will say, "I'm very interested to know what happened in the EPO or in a patent infringement action in Germany." Other judges will say, "That doesn't matter to me at all. I'm deciding a case here in the U.S. under U.S. law, and that doesn't matter. Different patent doesn't matter to me." And so even within the countries, you really have to understand the nuance of what is this interaction going to be between these different proceedings that are occurring all over the world. The other thing is on the point about SEPs, I think my favorite kind of nuance with that multinational SEP litigation is the anti-suit injunction and the anti-suit injunction. And so if you don't know exactly what Hemantji was explaining about how these courts are sort of stepping on each other's toes when it comes to making decisions in one country that will affect how a company will behave in another country. And one of the things that parties are trying to do is get a court to order the opposing party not to file suits in other countries. So that's an anti-suit injunction. In response, parties will ask another forum to issue an anti-suit injunction. Order the party not to ask for another court to order me not to file a suit. And so it's just a bizarre kind of arms race, I guess, trying to get one court to issue orders that are going to dictate what a company can and can't do in another country, which is just very difficult to do.
If I may just respond, it's a very good topic that you picked up, anti-suit injunction. And we've had very interesting judgment here in Delhi High Court here. So the law here is that you have to respect the sovereignty of the country, other country, and you cannot therefore be issuing anti-suit injunction, preventing another court to decide an issue if a party has gone there and seeking an adjudication. But you can surely prevent one of the parties before you from doing something which it is prohibiting it to do. So in a case like that, there was this case between the Chinese company and the Indian company, and the court said very well, I'm not injuncting you from prosecuting the litigation in China, but every time you infringe here, you will be paying an X amount which was prohibitive. And the Chinese court could not have done anything because that was an order passed. Well, to answer your question, I think anti-suit injunction cannot be actually the fair way to move forward. But therefore, it brings us back to that issue as to how do we resolve this, that different proceedings are opened in different jurisdictions, deciding the same issue, and there may be conflicting decisions in respect of the same issue. How do we resolve that if not going to be an anti-suit injunction? And therefore, the courts have to exercise this self-restraint. That if there is a court, maybe in any different jurisdiction, which has taken a view, then perhaps that should be respected, and the party should be encouraged to go and seek redressal over there, instead of getting in and deciding yourself. That's one way out.
Agreed. So Abhijeet, you come at this from a very different perspective, a very sort of data-driven perspective. Talk to us about how this sort of rise in global patent litigation has affected the way that Clarivate does business.
Thanks, Nirav. Thanks for asking me this question. So I can understand, like most of you from law firm, from pharma. So obviously, being associated with the data-driven company, generally what happens is that when you look at any kind of a litigation, kind of information at a global level, you need to have specific data or its insights, right? Then only you can understand what is happening in a particular country. In my opinion, how litigation impacted in recent times, that earlier it was more focused on the pharma segment, but in last 5 years, what I have observed through the data, that the high-tech companies like the telecom companies or maybe automotive companies or data management companies, those are getting more litigated. So it's covering around 60 to 70% space in the litigation as compared to the pharma. And obviously, in India, it is less litigation as compared to what is happening in outside India, like in US and Europe. But it's triggering in recent times, because you must have heard about the TCS, right? So regarding the litigation and all. But what also have observed is that non-practicing entities, those are coming into the picture, right? They are more taking advantage of this litigation, and strangely that they are targeting the big organization, which is a kind of a defendants in those cases, which is like Google, Microsoft, or maybe Samsung, those kind of a big giants considered as a defendant in those cases. So litigation is some kind of a challenge for the big organization, but some organization is taking the advantage of it, right? Taking the royalties or damages, settlements, those kind of things happening, and which is beneficial for them to generate a revenue as well. So when we discuss anything regarding litigation with the customers at a global level, we get a different aspects to understand. Some customers wanted to understand what is opposition happening, what kind of infringement happening. And sometimes the challenges that they are facing is the kind of a data which is not available in Southeast Asia region, for example. If they get the specific data and insights from a specific platform, then definitely that will give them a kind of a visibility about what kind of a next steps that they can do. And obviously, Mr. Hemant already mentioned that they have handled those cases in the past, and they are continuing doing that. But in my opinion, that while doing those kind of a litigation, you also get to know that what is happened in the past. So you can use that as a reference to tackle those arguments or tackle those cases in a specific industry. So data and insights is very important in such a era where it's not only about the innovation but also about the litigation, where in both the cases data will give you a correct guidance to take a specific decision about any particular case. Yeah.
Yeah, and that's a great point about NPEs. What we saw in the U.S. is that it's not just corporations and innovative corporations and practicing entities that are watching what's happening on a global stage and adjusting their IP strategy. It's NPEs too. They're doing the same thing. They're with the rise in litigation funding, with the rise in international filings of NPE cases, they know that the best thing they can do to get a return on their quote-unquote investment is find the forum that is most friendly to what it is that they're trying to accomplish. All right, and so Dr. Gururaj, so you, as our lone representative from industry, talk to us about how, in your role as head of IP at Panacea, how global patent litigation is affecting your day-to-day and your responsibilities in your role.
Thank you, Neeraj. And I would like to thank management committee to invited me as a speaker over here. And already all my co-panelists spoke about the legal litigation, but still I have few examples which is very relevant to pharma, because I am from pharma background and working with Panacea Biotec. So when you make the strategy, especially with the litigations, so litigations involve when you go into courts, US or Europe, it is a huge cost involved. So companies, especially whatever the organization, they need to think about the cost as well, because it is one of the main strategy. And another strategy is that when you go into courts, so federal circuit in US and all, it will take few years to come into the conclusion. So conclusion remarks will take longer time. So companies can have alternate strategy. Say example in US, inter partes review. It is very, you can go into US PTO, file the petition, and then within 18 months, approximately 18 months, you will get the result. From there, at least you come to know to what strategy, whether you need to still go ahead with courts and all, federal circuits or district circuits, or really some claims are already invalidated in the IPR itself. So you can still make a strategy to drop here itself, or still you want to make sure that in court you will get the favorable decisions. So one of the strategy for the pharma companies or other companies, they have to rethink before itself whether they want to invest huge amount and time as well to go into a federal circuit, or they want to go into a inter partes review, or another one is post-grant review. It is like pre-grant opposition and post-grant opposition in India. In US, you call it a post-grant review. It will also give within few months the result. So whether that patent really matters or very strong, or it can be invalidated easily. So you can make strategy based on the time and cost as well. Because when you talk about the cost, because companies mostly involve huge amount of when it comes to drugs. So it is a huge amount of money involved. So when you are going into US patent office for a IPR, it's just around 300K to 500K. So you can already know, so this much of amount I want to use it, and the conclusion within 18 months you will get. Whereas if you go into federal circuit or other courts, district courts in the US, it will be around 1 million to 4 million. It is a huge cost, almost few times of that. So you make sure as a company, if you are working, so whether you need to really go ahead with this much of huge amount involving in the litigation. So that is the one of the case. And coming into different jurisdictions, US, Europe. So some patents you may invalidated in the US, but still in the EPO, the laws are different. So it definitely it will be difficult to invalidate US and Europe, because US is non-inventive step is not involved that much of strong, so patents will be get, and innovator can, so many patents he will be granted. But whereas Europe and India is similar patent systems involved, so where the claims will be very narrow. So when talk about the US and Europe, you need to definitely strategize. Then in India, always section 3D is there. Most of the innovators are afraid or maybe narrow down during the prosecution itself. So here, not that the case. And apart from pharma. So the recent case I am going to discuss, most of the since morning we are discussing AI. So recently last month New York Times filed a copyright lawsuit on OpenAI and Microsoft. So they are challenging that the New York Times old newspaper articles are used to train and create a chatbots by both OpenAI and Microsoft. So there is a challenge here because the fair use doctrine is in US very easy because the laws are already this. But when it comes to India, it is a very difficult because these fair use and doctrine are not defined clearly in India. So we need to wait because it's the last month only the New York Times filed the copyright case. So we need to wait how this goes and whether if it is challenged in India, how the Indian courts will be responded. With that, thanks.
Thank you, Dr. Gururaj. You got right to the bottom line there. No pun intended. But I mean that really is the most important thing. Is what is the cost of the IP strategies that we're developing? We heard from Chandani on the last panel about how you decide where you're going to file your patents because you can't file everywhere. It's cost prohibitive. Same thing with litigation. You can't litigate everywhere. You really have to think about where can I bring my lawsuit that's going to get me the best return on investment, right? IP ROI. Budgets are limited, and you got to decide where you're going to spend those dollars. So that's appreciate those comments. I think a theme across a lot of the answers here was sort of coordination and communication among your teams, right? Especially when you've got parallel litigation going on. So I wonder, and I'll start back down the line again with Pratik, but can you talk a little bit about, in the example that you gave, the communication that was occurring between the teams and how do you sort of manage that challenge?
I think, of course, communication is the key to make anything work, especially in the litigation when you are constantly in touch with your counterparts in other jurisdictions who are handling the same litigation over there. So the synchronization between both the teams is very much necessary. It should not happen that you precede your step or you walk faster as compared to them. You end up taking some step over here which is legally going against your own client in other jurisdiction. That should definitely not happen. And for that, I think that teamwork and synchronization or communication is very much required. Especially the deeper understanding about the prevalent laws with regards to the IP or the general civil procedure which is enacted or which is enforced in the other jurisdiction, that is also required to be studied. Of course, the in-depth knowledge or analysis as a litigator maybe in India we may not do as compared to a US advocate or an attorney who is practicing in America, but we can always have a brief understanding about how the things work over there. Suppose, for example, if we try to get a suit dismissed over here in India on certain grounds, but maybe those grounds open up all our defenses which were very crucial for a litigation step which was coming up in the next month in another litigation which is going already in US. So you end up opening all your cards on the table today and then probably you lose because the stakes were actually higher in the other jurisdiction as compared to in India. I mean that is a very crucial step, that at least some basic understanding about the laws in other jurisdiction is much required, that synchronization is much required, and ultimately it is the interest of the client that everybody is looking after. So that would be an issue basically that needs to be considered. As far as the jurisdictional part is concerned, when we litigate anything in India, of course, as Mr. Singh said, that a major bucket of matters goes to Delhi because obviously Delhi High Court is a very dynamic system of conducting IP litigation. They have a specialized bench. But your client may not be that lucky to have a litigation in Delhi. He may be litigating at some rural place in India. At that time, what you do? The judicial system may not be that equipped. the understanding about the IP and the latest nuances which are coming day in, day out in India, it is very difficult to explain. So even that is also one of the, I would say, a bump on the road that comes, and that needs to be taken care of. And it is also very difficult to explain your client who is litigating in US, because at times that query comes that why in India it is not going ahead, and in America it has already reached to the trial. It becomes very difficult to explain how the things work over here. So there is a stark difference between the manner in which the litigation goes, considering the fact that the commercial litigation in India, obviously, considering the case that the criminal matters, the criminal jurisprudence has increased much. The courts are overburdened with criminal matters. So obviously the commercial matter and IP matter comes on a later end, except the Delhi jurisdiction, because they have their own bench. So I would say yes, communication is the key. Being on the same page, I think, is the key. Thank you.
Yeah, no, totally agree. I've had cases where, we have claim construction coming up, and the related patent in Europe is undergoing prosecution, and we'll have a meeting. We'll have a WebEx session where we explain what it is that we're planning to argue in claim construction, so that prosecution counsel in the UK can say, well, you can't say that, because if you characterize it that way, it's going to create a problem for us with respect to prosecuting this patent here. And that's just something that you can't. You have to have the conversations to really find those issues. Dr. Gururaj, how about you? Do you have some best practices for us for managing patent litigation on a global basis?
Yeah. See, team synchronization, as Pratik said, is very important, because we need to first itself clearly say what is our objective, and team should understand those things. And definitely claim construction, when you said different jurisdiction, it will be some confusion between the team, because different jurisdictions use different criteria, say sections wise or other things. So the team should be clear on that. When you are litigating in the Europe, what should be your strategy, and how the claim construction, how your invalidation strategy already made. And whereas in US, you should make different strategy, because it works differently, because both the patent officers are where, other court matters also, they work differently. When it comes to India, definitely it is other strategy you need to adopt, because here more stringent strategy, so you can use all your weapons, section 3D, section 3E, and whether section 3K and other all things. But whereas in US and Europe, you need to be very clear to your team members, so understand what they make and then go ahead with the strategies. Yeah.
So I think I'll open it, before I ask for a kind of a final word from each of our panelists, I'll open it up if there's any questions that you have for any of our panelists here. All right, seeing no questions, I'll ask for a final word from each of our panelists. Hemantji, can I start with you?
Well, I would say yes, as Pratik said, that communication is the key. Global strategy is, of course, now the rule, but what should form part of that strategy? And communication comes right on the top. And I can tell you that we have had experience of litigation where we found that the client had one person globally strategizing, right? And that person knew exactly what's happening in which jurisdiction and kept us informed all the time that this is where the claims have been invalidated. This is the reason on which it has been invalidated. We could evolve strategy how to distinguish it so it doesn't impact India, and so on and so forth, So communication is extremely important. Keep your counsel informed. Keep your discussions going on. So nothing should come as a surprise to your counsel. That's the key as far as I'm concerned.
Yeah, it's really amazing when you come across somebody who is like that, capable of keeping track of what's going on in so many different jurisdictions. I have a hard enough time keeping track of what's going on in my own cases in the U.S. But every once in a while, you come across an in-house counsel who, or some business executive who just has a mastery, their finger on the pulse of everything that's happening with their IP. It's very impressive.
You know, I mean, that's where we need to learn. These companies, which are these global players, so they will have these IP heads. One IP head is looking only after one molecule. That's his job. But he's ensuring that that molecule is defended in every jurisdiction. So if the company has got 20 molecules, there are 20 IP heads looking into it. And that person doesn't know anything about what's happening in respect of anything else. That's a kind of a professionalism they have.
Abhijeet, maybe a final word on... go ahead. Yeah, please go ahead.
Please. As Hemant sir said, it is very difficult for a pharma companies, each molecule having a IP head because because we are handling so many of molecules. So I know as a IP head, so under me around 50 molecules. Still, sometimes we are confused. But think what said by Hemant sir, that communication, because communication, you will be central point, because as a IP head, you are looking all the molecules, but you can distribute that work to your team members. Each team member, you have to communicate clearly that this is the things, and different countries, different scenarios are going on. But definitely it is a very hard to having each molecule IP head, as I know. I don't know other companies, but it is communication is very important. So you need to communicate, make team alert on the what is happening and where the results are coming. So how can you strategize next country to go ahead with that molecule? Thanks.
Yeah. Abhijeet, from the perspective of a final word, sort of for folks who are sitting in the audience and maybe on the verge of facing global patent litigation, what are some of the tools at their disposal that you sort of recommend for them?
So obviously, I think the kind of approach that Indian organization that they are taking from the protection perspective, IP protection perspective, is that they know their markets. So they are focused on those markets where they know that their business is coming. So what I wanted to highlight here is that know your market. That is the first thing that you need to understand from the organization perspective, where you can generate the business. And second thing is that I would also like to highlight like the data. So your strategy should be backed with the data. And obviously the Clarivate company, as you know, that they have a lot of platforms. So like for the patent innovation or patent intelligence, you can use the Derwent innovation. For the litigation, Darts IP. So in my opinion, having those kind of platforms in the organization give you a correct guidance and help you to build the good strategy at a global level. And it will also help you to tackle the competition in terms of any particular industry, whether it is a pharma, telecom, or any other industry. Yeah.
Thank you. And then Pratik, how about a final word from you?
I think to sum up, I would say that of course the due diligence, Mr. Singh very correctly said that before we attack the loopholes of the other side, we must do our own due diligence and find out what are our weaknesses. Are we goofing up in some other jurisdiction as far as the patent prosecution is concerned or not? And because those things obviously will come against you as a defense in your proposed action. So I would say that the chronology of the action that you take matters, apart from the law in your support, and probably it's at times in certain kind of litigation, it is not always about securing an injunction, or especially when you have a weak case. It is also about creating a forceful pressure on the other side by taking such litigation steps in multi-jurisdictional areas that can also make you win the game, even if you don't secure an injunction. So you make the other side famish, and you may even then win a case at the end of the day. Like the example of anti-suit injunction, I mean, that was a phenomenal thing which happened. But ultimately, what is the result of that? One court denying the other side to take an action, then another jurisdiction telling this player not to take an action. Ultimately, they reach an impasse. Ultimately, it comes down to the liability of the person and what is at the stake. So the person who has higher liability and the stakes are high for that party, he will ultimately succumb and he will come on table. I think this is what the end result is in such scenario. Thank you.
Well, thank you. Thank you for all of those insights. Thank you to my esteemed panel here. I really appreciate your insights. I won't say too much more. I think it's all been said. You know, cradle to grave, your IP strategy needs to be global. If it's not, you're doing yourself, you're doing your company a disservice. So think about that as you sit down to scratch out your strategy. Thank you. Thank you all.
Can have some questions. It was a very interesting discussion. Thank you. So any questions? We have time. So we'll close this session. Carry this torch of knowledge to illuminate your path in the days to come. Deep gratitude to our insightful panelists for sharing their expertise and enhancing the quality of our conversation. A big thank you to the experienced moderator for his vital role in making the session engaging and successful. Thank you. Time for mementos.